In a judgment handed down at 10 a.m. this morning, the High Court has shown huge frustration in the claim between Prince Harry and News Group newspapers, aka The Sun, to the extent that they can't even really agree what it is the trial's going to be about and what they agree and disagree on, with 44 pages containing 49 separate items of disputed elements. So I thought I'd go through some of that with you in this video. And if I could just ask you one small favor, if you could please subscribe to this channel and hit the notification bell so you get notifications of new videos. Like the video, that helps YouTube to spread my channel to a wider audience. I am cruising to 600,000 and my goal is at least 1 million subscribers so that I know that I've helped 1 million people understand law. Thank you for doing that. And now let's get into the video. So first of all, let's just have a bit of a recap. Now, first of all, the court likes to have a finality. The law likes to have a finality and likes to have these things done in a reasonable amount of time. But bearing in mind this claim was filed in September 2019, this shows you just how long this can take. But the court has been hugely frustrated with this case in words that are quite unusual for the High Court. So let's take a look at this. So it says here, Mr. Justice Fancourt says, I handed down a judgment, the May 2024 judgment, which decided that Prince Harry failed to draft amended particulars of claim that complied with the order of July 23, which granted permission in principle for certain proposed voluntary amendments to the particulars of claim and refused permission for others, and refused permission for yet further amendments unless appropriate particulars were provided. What that means in English is when you have a claim or you want to bring a claim against somebody based on a certain set of facts, you have to particularize that claim. You can't just say, here's what I'm saying and this is why I want the money. You have to set out the particulars, the very details and the reasons, the factual matrix that gives rise to a cause of action, which then gives rise to damages that you seek from the other side. It's no good just to say, I think they did this, therefore they owe me money. You have to particularize it. And if a claim is not sufficiently particularized, the court will either strike that out or it will just fail because it's not properly particularized. And so the judge has given various directions throughout this case, and there's been various amendments back and forth. But today's judgment is the culmination of sheer frustration by Mr. Justice Fancourt over these amendments and the back and forth. Paragraph 7 highlights that very clearly and says, it's clearly imperative that the content of the pleaded case is resolved as soon as possible. I had perhaps unduly optimistically expected that the residual disputed material would be limited in view of the length and detail of the May 24 judgment explaining exactly what was permitted and what was required. But in the event, I'm faced with a table of disputes running to 44 pages with 49 separate items or groups of items disputed, only a handful of which were eventually agreed. This formed a table which the judge went through in this judgment. 34 pages of dense submissions by News Group newspapers in support of their objections, which amplify the content of the table. News Group submits that I should now rule that the consequential amendments do not give effect to the July 23 order, and that the voluntary amendments for which permission is sought should be refused. The judge said, I've previously indicated to the parties that this individual claim, although it raises important issues, is starting to absorb more than an appropriate share of the court's resources, contrary to the requirements in the overriding objective to deal with cases justly and at a proportionate cost. Just to explain that a little bit, there is what we call the overriding objective, which the court will take into account and the parties are supposed to assist the court in achieving, which is that all cases are supposed to be dealt with justly, fairly, at proportionate cost, with regard to the strength of the parties, the complexity of the issues, the importance of the case, and so on. And so the judge is saying here that it is starting to absorb more resources, more court resources, than would be justified in maintaining this objective. The judge says it is now doing so. The claim at times resembles more an entrenched front in a campaign between two stubborn but well-resourced armies than a claim for misuse of private information. It is unsatisfactory, to say the least, that the court should be faced a second time with having to resolve such a large extent of disputed material on amendments to a statement of case. Again, this warrants a little bit of explanation because the statements of case should be relatively straightforward. They should be just a factual set of circumstances upon which the claimant or the defendant relies to either make or defend the case, and it should be relatively straightforward. Complex cases might run into quite a few pages, but nonetheless should be straightforward. So the judge here is complaining about such a large amount of disputed material and amendments to statements of case. The judge says, I've also previously indicated that this claim will not be adjourned and will either be tried in January 25 or settled, since it was first issued as far back as September 2019 and has been stood out of eligibility for 2 previous listed trial dates. That remains the position. So this is the judge expressing frustration that this is not going to be adjourned again. It's been going on far too long, since September 2019, and it's either going to be tried in January 25 or the parties must settle the case before then. And so this is essentially the judge exercising the court's case management powers to say that this is going to be tried in January next year. Whatever the position of the parties, it's going to be tried or settled. So what is the real key dispute here? Well, essentially, Newsgroup newspapers object to 49 specific points in Harry's claims, including allegations of landline voicemail interception, live call interception, and other forms of alleged unlawful information gathering. The judge was also unhappy with how the parties approached these amendments generally, and said at paragraph 12, it's important to bear in mind that there are 2 different types of proposed amendment in the final draft amended particulars of claim that are unresolved. 1, consequential amendments to give effect to the 2023 order that in effect the remaining causes of action for misuse of private information must be disentangled from the previous allegations of mobile voicemail interception so that it's clear what causes of actions remain, and 2, the voluntary amendment to add permitted new claims where in the May 24 judgment the judge concluded that they were permitted in principle but inadequately pleaded, and that this second category comprised of landline claims as defined in that order, to include landline voicemail interception, live phone call interception, bugging, analog scanning, and so on. But the judge then said these are the only matters that should be live at this stage. All other proposed amendments were either permitted or refused by my May 24 judgment and order. The revised draft directed by the May order was therefore not a further opportunity for Prince Harry to plead discrete new causes of action that had not been pleaded in the original draft. Nor was the table an opportunity for Newsgroup newspapers to raise new objections in the content of the previous draft. Regrettably, it appears to me, to varying extents, both parties have crossed the line in these respects beyond what was indicated in the May 24 judgment was permissible. Thus, some of Newsgroup's renewed complaints would not be entertained save where criticism relates to the newly drafted material itself. In this regard, Prince Harry makes quite clear in his draft and in the table in his submissions that his causes of action are limited to those specified in paragraphs 22A to I of the draft particulars and parts G and H of the schedule, so that it's pointless for Newsgroup to complain that it's unclear whether the material is in the draft is relied on as a cause of action. So you can hear there how frustrated this judge is, where the parties just cannot resolve these issues between them in accordance with the orders that he's made previously. So in short, some of these were permitted and some were not. The judge says it follows that I grant permission for amendments in the draft except to the extent of the matters identified under rows above. Where in relation to any of those rows I indicate that permission would be granted on a particular basis but not as pleaded, Prince Harry, the Duke, must either remove the amendment or the draft or vary the plea as indicated. So one way or another, this trial is going to go ahead in January. So now they'll have to make these amendments or remove them as indicated. They'll have to have witness statements exchanged and the trial will be going ahead in January next year. Or they'll have to settle it by then. And after all is said and done, they might even settle it before it gets to trial. But I hope you found that useful. Please do remember to subscribe as that helps my channel grow. And as always, thank you for watching.